If you believe you can infringe on a smaller brand because you're bigger and better, trademark law says otherwise. Take a look at this.
Australia's High Court ended a 17-year trademark dispute between Katy Perry and an Australian fashion designer born with the same name, and the Katy you've probably never heard of won.
Ownership attorney has entered the chat. Katy Perry, an Australian fashion designer, used and registered her trademark for clothing before Katy Perry, the singer, ever sold a single shirt in Australia. When the singer prepared for her Hello Katy tour in 2009, her team found the registered mark. They filed a late opposition, they sent a cease and desist letter, and then they still decided to sell branded merch at concerts anyway. That's when the dispute began. The designer took it to federal court in 2019. I mean, she won at trial, and then she lost on appeal, and now she just won again at Australia's High Court. And the court ruled that the designer trademark was valid, and the singer infringed upon it, although the singer argued that her name, her fame could not be divorced from her reputation and her being known worldwide. That alone didn't cut it. Here are 2 lessons from this case that actually matter legally in Australia and the United States. Lesson number 1, use and registration beats reputation. The designer used and registered her trademark for clothing before the singer ever entered that market in Australia for the same thing. Trademark law does not stop at fame alone. It cares who uses and protects their trademark according to federal law. Duration, extent, and geographic reach are things that are taken into consideration when a trademark is not registered in a jurisdiction. Rights may be limited or revoked based on these things. You have to register in the right category, in the right country, at the right time for full protection, period. Lesson number 2, having knowledge about a federal trademark and selling anyway makes you an intentional infringer, not an innocent one. Katy Perry's team knew about the designer's registered trademark in 2009 and still sold merchandise at her 2009 concerts in Australia. That had to stop, but they also had to pay big money for that action. Knowing a trademark exists and moving forward anyway in trademark law, that is not a gray area. It is infringement. An intentional infringer is one who knowingly and willfully infringes on a trademark. Courts look at, or trademark law look at, is evidence of bad faith, deliberate conduct, or willful blindness to establish the type of intent. Willful blindness can include failing to do a trademark search, especially on trademark databases. You will be deemed an infringer if you decide to go ahead and use a trademark that is already out in market. The only question left is how much it will cost you. Ownership is not about who's bigger. It's about who did the legal work first. This is why I'm the ownership attorney.